Okay, hello everyone, and welcome to this winner panel. We look forward to discussing the modernization of competition law in the digital market with you in the next 1.5 hours. And of course, we know that digitization is a common challenge across jurisdictions, bringing benefits to consumers and to businesses, but also posing risks when markets and societies are dominated by large players. And an issue that many jurisdictions are nowadays dealing with is to what extent the existing competition law framework is still capable of addressing competition concerns in digital markets. And in this panel, we will be discussing where Indonesia and the Netherlands stand today and what we can learn from each other's experiences. So my name is Inge Graaf. I work at Tilburg University in the Netherlands, and I'm joined by 3 other speakers. And I would like to first introduce you to Yuli Wahyudingtyas. She's an associate professor at the Atmajaya Catholic University of Indonesia. And Yuli and I actually have strong, close ties because we used to work together at KU Leuven in Belgium a couple of years ago. And I still have very fond memories of that time. And the idea for the panel also came from Yuli, so thank you for that very nice initiative, Yuli. Then representing Indonesia as well, we have Tivana Arbiani Kandini. She's assistant professor and full-time lecturer at Atmajaya Catholic University of Indonesia. And then to discuss the EU perspective, we are very happy to have Alessio D'Amico on board. She's assistant professor at the International and European Law Department of Utrecht University in the Netherlands. So the way we will run this panel is that we'll have 3 rounds to keep it more dynamic and to have several shorter interventions. In the first round, we will start by some perspectives on the current state of competition law and competition enforcement in Indonesia and in the Netherlands or the EU. And then in rounds 2 and 3, we will dive a bit further into selected issues. And of course, we also look forward to hearing from you, from the audience. So if you have any questions or comments for the panel, please leave them in the comment section and we will put them to the speakers during the discussion. So I think with that, we are ready to get started. So then, Yuli, I'm happy to give you the floor for a first introduction into the state of affairs into Indonesian competition law and competition enforcement.
Thank you so much, Inge, for the introduction and also for hosting the panel. So allow me to share a little bit about what's going on in Indonesia in terms of how we are dealing with competition with digital, the development of digital market in Indonesia. And especially now that we are also dealing with even more global players and also other challenges. Allow me to present, to share my slides.
I think your slides are already up. So if you would like to move to the next one, I think you can indicate and then someone in the back will take care of that.
Okay, sorry. Yeah. Okay, please, the next slide, please. Thank you so much. So I will start with the legal basis. So what is the legal basis for Indonesian competition law? Basically, we go back to 1919, some years before, when we started with our competition law number 5 of 1999 that we are still having at the moment. We are planning to modernize it. That's why this conversation is very important for us. But yeah, we will still need to wait or to work on that move. And also, it is important to mention here, though I don't put it in my slide, that we also have another law dealing with. We are talking about how we deal with big companies, but we are dealing from the other side. So we are having law for protecting small companies, so micro, small, medium, small companies. And in this law, it is especially emphasized that big companies should not abuse their power in their relationship when they're creating agreements with small companies. And with that, I would like also to go a little bit to some development. The first that I would like to mention is the development with law number 6 of 2023. With this law, there are three, well, among other things, there are three main important developments. The first is the removal of the maximum administrative penalty. So this is an important development, because with this, it makes also the sanction becoming more effective. So it puts more deterrence effect for the companies who infringe the law. And the second is the removal of criminal sanctions penalty. And this is also something that I would say that I appreciate this part, because I think let's stay with administrative sanction instead of penalizing competition law violators. And then the shift from district court to commercial court for objection procedure. So this is again something procedural. And then we have also an update on how we define relevant market in 2022 with the ICC chairman regulation. And some points that are pointed out here is the recognition and how we would consider the role of intermediaries that is increasing now with the development of the digital market, and also the role of network effect in the definition of relevant market, and the role of data, especially personal data. And the next development is we have also guidelines on defining negative impact on competition, on competition. And in these guidelines, three main points are: first, the principle that we go to the direction of the substantial lessening of competition, the SLC, when we assess the impact of certain conduct to competition. And also we use this, or we call it with or without test, whether with this particular conduct there is a negative impact to competition. And then we also recognize the competition level test in these guidelines. And then the next development is the update or the updating of the merger guidelines. In here, something important that we have is the expansion of the scope of assessment that's previously under law number 5 of 1999 is rather limited. So we limit, for instance, the assessment of the acquisition only to acquisition of share. And now with these guidelines, we have a tool to expand the assessment also to include acquisition of assets. And then in regional context, we also have a new development. And we have in ASEAN is something different from the European Union, of course, but something that is that we are currently in is the promotion of the greater regional competition cooperation. And next, please. Just a quick recap on the new frontier that we are facing now in Indonesia is that as I mentioned earlier, about the increase of the role of personal data for businesses. And currently, we have new Indonesian data protection law. It was already entering into force in 2020, but only in 17 October this year, it will be effectively enforced. And the scope of application, we also learned from the EU GDPR that it covers not only private entities, but also public entities. This is something important. But the thing is that we are still waiting for the data protection supervisory authority. So from the enforcement point of view, this is something that we still need to see. And about current further, I think we will leave it to the next round. So we will discuss about what we have currently in Indonesia. Back to you, Inge. Thank you so much.
Yeah, thank you, Yuli. It's a very interesting short introduction, and I can already spot several links with ongoing issues in the EU. You already mentioned the GDPR, but also in the EU, for instance, the market definition notice has recently been updated, and the Commission has also published draft guidelines on exclusionary abuses of dominance. So we can already spot several analogies there. But beyond this, another important development in the EU is the introduction of the Digital Markets Act. And in the next couple of minutes, I would like to run you through some of the main features to understand how it functions and how it relates to EU competition law. So if we look at the next slide, we will see what the main features of the DMA are. So first of all, an important difference with competition enforcement is that the Digital Markets Act, the DMA, is a form of ex-ante regulation. So it consists of obligations and prohibitions that are adopted by the EU legislator, which apply like irrespective of any further investigation. So while in competition law, the competition authority would have to investigate, look for harm, look for anti-competitive effects, the DMA's provisions apply in an ex-ante manner. Another important aspect is that the DMA is exclusively enforced by the European Commission. So the national level, also the Dutch Competition Authority, the ACM, does not have so much powers. At least it does not have any enforcement powers, but there is some cooperation and coordination with the national competition authorities where, for instance, they can receive complaints, run investigations, but they have to pass on their findings to the European Commission, who then takes a decision and does the actual enforcement. And also very important to notice that the DMA complements EU and national competition law, so it does not substitute it. There is also some room at the national level for member states to adopt additional rules for digital markets, as long as they have a slightly different scope than the DMA, although there is still discussion on what exactly the scope there is for national competition law to still regulate digital markets in their own jurisdiction. So if we then move to the next slide, when you look at the objectives of the DMA, you also immediately see that indeed the purpose is to complement EU competition law. And one of the first provisions of the DMA has the objectives, which are contestability and fairness. So there you already see a distinction with EU competition law, which normally we regard as the objective to promote competition for the protection of consumer welfare. Here, the focus is really on contestability, where one of the recitals defines this as the ability of undertakings to overcome barriers to entry and to challenge the gatekeeper on the merits of their products and services. So here the idea is that some of these markets have such economic features that it becomes very hard for newcomers to challenge the gatekeeper, and that the DMA is an instrument to increase that ability to overcome these barriers to entry and to have more contestable markets. The fairness objective is defined as an imbalance between the rights and obligations of business users, where sometimes because of the larger bargaining power of the gatekeeper, it can obtain a disproportionate advantage over business users. So these objectives, contestability and fairness, already show you that there's a slightly different focus of the DMA versus the protection of consumer welfare in EU competition law. Then when it comes to the scope on the next slide, there's two elements that play a role. The DMA applies to so-called core platform services, and there is a fixed list included in the instrument where you see the different services listed here, from social networks to advertising to browsers to operating system to NICS, which stands for interpersonal communication services. And then another important element in the scope is that you need to qualify as a gatekeeper. So you see the companies there on the left, which the Commission has already designated as a gatekeeper. And there's 3 criteria in the DMA that need to be applied. And there's also quantitative thresholds that if you meet those, there's a rebuttable presumption that you qualify as a gatekeeper. So if that is the case, and if you offer one of these core platform services, then for those core platform services, you fall under the obligations of the DMA. And here you can also already see a distinction with competition law, where in competition law you would usually have like one dominant firm per relevant market. Here we don't have relevant market, but we have core platform services where also different companies can offer such a core platform service, and there is no one dominant firm as we would have in competition law. Then when it comes to the obligations and the prohibitions on the next slide, I won't have the time to take you through all of them. Alessia later on will give you one example. But there have been attempts to make like a categorization of the different obligations and prohibitions that the DMA includes in Articles 4, 5, and 5, 6, and 7. And this is one example of such a categorization. So this includes practices relating to leveraging from one service to another, where, for instance, this is about self-favoring behavior, where a gatekeeper puts its own services higher up in the results. Another category is to promote business and end user switching and to promote multi-homing. So for instance, allowing the installation of several app stores in an operating system. It's also about opening up platforms and data. For instance, data portability is an example, both for individuals and for businesses, where they can move their data to another platform, and increasing transparency. And there, for instance, provisions on creating transparency in advertising systems where the gatekeeper has to share some metrics with business users. Then if we go to the final slide, we will see like a table comparing abuse of dominance and the DMA, where you indeed see the difference in approach. So market definition is very important in dominance cases. It's sometimes also quite complex, often litigated. In the DMA, we don't have this. We work with core platform services. Dominance, also quite complicated. Usually you look at market shares. The burden of proof there is on the competition authority. In the DMA, we look at gatekeepers, where there is a rebuttable presumption if you meet certain quantitative thresholds, so that the burden of proof is actually reversed. And if you are a gatekeeper and you provide core platform services, you will have to come forward and then explain to the Commission how you comply with all of the obligations. So also in terms of the infringement, where in abuse of dominance, the burden of proof is on the Commission, under the DMA, you have self-compliance. Then in terms of remedies and sanctions, the two are more or less the same. And of course, the timing is also different, where abuse of dominance is ex post liability. The DMA applies ex-ante, and there's also a mechanism for non-compliance. So if there is 3 non-compliance decisions in 8 years, the Commission can do a market investigation to impose further behavioral and structural remedies, so to have an even stronger deterrent effect on gatekeepers that don't comply with several of the obligations of the DMA. So this is just in a nutshell what the DMA is entailing. So this is an additional instrument that is now being enforced in the EU, and where we also see more and more the impact of it and the investigations that the Commission is now doing. So with these 2 short introductions into the current developments and frameworks in Indonesia and in the EU, we can dive a bit further into the challenges that the 2 jurisdictions are facing. And as Julie already mentioned, beyond the challenges within competition enforcement, there's also challenges in terms of how competition law relates to other legal regimes, where data protection is indeed one very important one. And in the second round, we will be paying attention to this issue. And for that, I'm happy to pass the floor to Alessia to speak about the relationship between the DMA and data protection law from an EU perspective, because as she will be explaining, the DMA also has provisions that actually refer to concepts from EU data protection law. So Alessia, the floor is yours.
Thank you very much, Inge, and thank you for this great introduction to the DMA. It makes my job easier now to build upon what you have just said. So as Inge mentioned, I will speak about the relationship between the DMA and data protection, so the GDPR that we have in the EU. And so the point really is here to discuss the challenge that we have with a very present business model, which is the one to monetize personal data. And also we will talk about the pay or okay model that more and more tech companies are using. So giving you either a choice of paying for a service or like paying with monetary terms, or disclose your personal data so they can monetize that. So yeah, if we can move to the next slide. So, well, this is just the introduction to the first part of the DMA that Inge already mentioned. So we can move on straight onto the particular obligation, Article 5, which Inge also mentioned. So Article 5.2 is what we're concerned with when we talk about what I just mentioned, the relationship between the DMA and the GDPR and the role of data. And here the DMA prohibits gatekeepers to process data in certain ways, and we don't have to go through all of it, but basically it's like combining data coming from different parts of the services. And if you see at the bottom of the slide, so gatekeepers may not process data in certain ways unless the end user has given consent to do so. And consent here is defined as under the GDPR, so that there's a direct link between the DMA and the GDPR, and the DMA borrows the definition of consent that the GDPR has. So moving on to the next slide. So the question that I have been trying to answer is, so what is the relationship then between the DMA and the GDPR, especially when it comes to what the question of consent. So what consent needs to be given? What is valid consent? Is valid consent under the DMA the same as under GDPR? And well, what we like the concern underlying is really to have a coherent and effective system overall, because of course, if the DMA starts to introduce new concepts that are different than the ones that we have under the GDPR, that might make the whole regulatory framework more complicated. So I will get into this now in the next slide. So one important aspect is that well, under the DMA, the gatekeepers, as I already mentioned, they have to rely on consent if they want to process data in the ways set out in Article 5.2. And under the GDPR, data controllers have different legal bases. So the consent is one option, but there are also other ways, other legal bases they can rely on to process data. And one of them is if it's necessary for the contract performance, or if there is a legitimate interest for processing the data. But then when we look at actually the cases that in which, for instance, Meta was processing data in ways similar to the ones set out under Article 5.2 of the DMA, also under the GDPR, Meta was not allowed to rely on the other legal basis and was only allowed to rely on consent. So what this means really is that when it comes to the type of processing set out under the DMA that require consent as the only way that will allow gatekeepers to process the data, it aligns in the way we have been interpreted the GDPR that also obliges data controllers to get consent. The next slide. So now we know, okay, so consent is necessary for this type of processing. What is consent? What are the requirements for valid consent? And here, this is really the, I think, main part of the analysis, because the feeling that many people got with the DMA, it was trying to fix the problem that the GDPR encountered in terms of freely given consent. So the fact, for instance, that consent, that like us as users, we never really have all the information. We don't really want to go and read it, and we just consent without really thinking about it because we just want to access the service. And also that in some circumstances, we actually don't really have a choice, because if we want to use a dominant platform or platform where a social media platform, for instance, where all our friends are, we will just consent because there is no other option, because, well, we need to be on the platform to communicate with our friends, for instance. So this is all a big problem, has been recognized under the GDPR when it comes to consent. And the DMA, in a way, tries to solve it a little bit. And here you can see in the table, I compared provisions from the DMA and the GDPR, which seems to suggest the DMA wants to be a little bit stricter. And for instance, so it tackles, on the one hand, the problem of consent being informed and unambiguous. We don't have to go, and we don't have the time to go through it in detail. But if you look at it, the words used seem to be a little bit stronger under the DMA. For instance, it talks about not being able to deceive and manipulate users, and also the fact that proactively, consent should be proactively presented in a user-friendly way. So these words also seem to indicate that, the problem of dark patterns, and that consent must be as transparent as possible. And in the next slide, you see more important, I think, provisions when it comes to whether consent is freely given. So this refers to what I was saying about being like the data controller being a dominant company, and the fact that, well, and this was the issue in the Meta case that went before the Court of Justice. And so the question of, can consent be freely given if there's a dominant company involved? And here, under the DMA, what it says is that users should be freely able, like they should be able to basically opt out of giving consent, but still have access to the service, so that there should be a less personalized but equivalent alternative. So basically, that it shouldn't be possible for the platform to say either you give consent or you don't use the service, but that you should be able to refuse consent and still have access to it. Now we get into what I was mentioning, which is the pay or okay. It seems that under the DMA, what is suggested is that, okay, you have to give an equivalent alternative, but you can charge for it, right? So then that would lead to two scenarios. Either you give consent or you don't give consent. The gatekeeper still needs to give you access to a service, but can charge you for it. Next slide, please. So comparing the two, what does it leave us? It seems that the DMA does have a bit of a stronger emphasis on when consent is valid and freely given. But overall, when we compare the way also the GDPR has been interpreted in this regard, we can see that under both, actually, imbalance of power is relevant. And also under the GDPR, for instance, in the Meta case, it was taken into account that Meta had market power, and that made it impossible for users to give consent freely if they were not given an alternative. And so then I think it means that under both, they can be consistently interpreted, the GDPR and the DMA. And what needs to be provided is that data subject can opt out from the data processing and still use the service. So next slide. So that's my last slide as well. So, well, there are a lot of questions that are still open though. For instance, what does an equivalent, not personalized service look like? If it's of inferior quality, well, maybe it has to be of inferior quality because of the non-personalization, but to what extent? And also, what fee can be charged for it? Well, this is a new big question, because of course, if the fee is really high, can you really say that given consent is then freely given just because you have an alternative that is paid, if it's unreasonable what is asked for it? And here we have moved now, the discussion have moved on to a third option that might be needed. And both the Commission and the European Data Protection Board seem to suggest that we might need to have a third option besides the giving consent, giving money, but there also needs to be an option to basically not give consent, but also not having to pay. Of course, that would make the free, it would be easier then to actually ensure that consent is freely given, because then you do have an alternative where you don't have to pay. But then the big question is, how do we reconcile this with the business models of these big tech platforms that rely on data to monetize their services and want monetary compensation if they don't get the data? How can they run their business by giving you access without data and without the monetary compensation? Okay, that is it from my side. Thank you very much for your attention.
Thank you very much, Alessia, for that clear presentation. I think you showed us that the relationship between the DMA and data protection law still raises many questions in the EU as well. So we know that unfortunately you cannot stay until the end of the panel. So thank you very much for making the time to be here, and we'll keep the conversation running anyways.
Thank you very much for having me.
Then let's hear from the Indonesian perspective. Yuli, back to you. What can you tell us about competition and data protection in Indonesia? You already started to discuss it in your introduction round, but happy to hear more from the state of affairs there.
Thank you so much, Inge, and also Alicia. It's very, very insightful presentations that you have delivered, also Alicia. And could we go directly to the third slide? Next, please. Yeah, thank you. Yeah, so after we see how it is how things developed in the European Union, and let's see how things in Indonesia. I think we have some commonalities, and now with the Indonesian data protection law, with the enactment of this law, I think we can be a bit relieved that at least we have a regulation that protects our personal data, although there are many questions that remain open. So what we are struggling at the moment is, we really go to the basic, Inge. I think that apart from what I said, we are waiting for the Data Protection Supervisory Authority. At the moment, we also are dealing with how we raise awareness, how we change the mindset. Alicia mentioned very nicely about consent, and this is something that also we are really well struggling, trying to understand. I mean, in our behavior, not only for data controllers actually, but also for data subjects, what consent means, because it is very often that consent means in practice when you sign something, when you click okay, yes, agree, but it is not necessarily substantial or real consent. And this is something that we change with the new data protection law, and we are at least I would say I'm very happy with this development. We still need to move forward, but I think we start from somewhere. And also another thing that we are trying, we attempt to do at the moment is to adjust with the new law. First of all, to ensure compliance, but we also need to harmonize not only the existing regulations, but also institutional terms. We need to make sure that everybody can work together, and we can be sure that who can do what and how. Yeah, and this is something that we need to settle. And then we also need to say educate the law enforcers or train. So awareness for everybody, and also training for law enforcers, including courts, because it is also possible that that personal data cases go to court, because we recognize three types of sanctions, namely administrative sanction, penalties, fees, and also we recognize civil procedures, damages, and then we also recognize criminal sanctions. So this is something that is not really the same with the UGDPR, I think, but please feel free to comment on that. And at the moment, because we still don't have the administrative enforcer, we actually rely on these two. But there are more problems or more difficulties in using the civil procedures than the criminal procedures, because when you use the civil procedures, it means that you go directly head to head with the data controller, while when you go through the criminal procedure, you go through the law enforcer. So this is something that we are having at the moment. With the current issues, as I mentioned earlier, you also have mentioned with the increase of the role of personal data for companies, we experience that too, and we also notice this. Well, Inge, you remember maybe a decade ago when we talked about services with zero prices, and then we thought, okay, maybe this will not this will no longer zero. in the future. Maybe it will be some euros, some dollars, or some IDR. And now we can start to see this happening. And so companies that rely on personal data, we can see that this services with zero prices, well, it still exists, but slowly you put prices in different ways. So how would we see this? Yeah, and then also the shift of the role of the digital platforms as well. You have the DMA dealing with gatekeepers. I think something that that resonates also with what happens here. That those platforms, they are no longer just intermediaries, because they eventually are now the decision makers, the price setters, rule setters that define who can do what are the prices. And the problem here, I think, is one of the problem is that we have difficulties in obtaining evidences. And this has something to do with I think at least two points. The first is with with the difficulties to prove violation of competition law itself in the digital market, and so that's already complicated. And another thing is that we have quite limited in Indonesia. Our competition law authority has quite limited authorities actually to obtain evidence. And also there is an issue about qualification of anti-competitive conduct. For instance, when I think Alicia mentioned a little bit, when you have poor privacy policy, but this poor privacy policy results from a dominant power in the market. Would it fail under competition law, or would it fail under data protection law, or would it fail in between? We still have not gone that far, but it's already there, this question. And then also slowly we can see this issue about personal data. Well, we often say personal data is an asset, but of course this is not like any typical asset, conventional asset like offices or I don't know, computers maybe, or my desk. This is something different. But then this question also needs to be responded. And this has something to do with again with the issue about consent. If a company, so A, is selling its asset to B, another company, and with selling the asset, meaning also shifting the contract, so moving the contract, the contract between A and C to B and C. And now, in this contract, there is also an agreement to process personal data. So, because we want to talk about consent. And then we have this question whether this kind of agreement, whatever agreement you call it, whether it could also fall under something that can be transferred to another company when you sell your asset. So I think this needs to be assessed carefully, and yeah, and this is why we need. It's very urgent that we need this personal data protection law to be implemented, to be further regulated, and we have also the enforcer. And then also another issue about whether our personal data can affect company value directly, or can it affect market power directly. This is also something that we are starting to see in our in our daily life, or maybe if we want to say in cases. So then the last part that I would like to point out is this link between not only between competition law and data protection law, but also the link between the competition authority and then the data protection supervisory. And those are things that we are dealing at the moment. From academic point of view, Inge, this is interesting for me, but in practice, it could be really a real problem. So with that note, get back to you, Inge. Thank you so much.
Yeah, thank you, Yuli. Very interesting to hear these developments. I think indeed interesting to hear about the criminal sanctions for data protection violations, because that we don't have. Like some member states of the EU do have like semi-criminal sanctions, but these are mostly fines at the national level. So that's definitely a big difference there. And I think indeed, like most of the enforcement, both in competition law and in data protection law, still happens through public enforcement. And sometimes their decisions are then used as in private cases to claim damages, for instance. But like the private enforcement route is becoming more important, but still it has some challenges as well. So it's interesting to hear that in Indonesia, yeah, there is still work to be done in terms of creating the enforcers and improving the public enforcement route. There's already one question from the audience that what I would like to put to you, Yuli. And this is a question about what Indonesia can learn from the EU's Digital Markets Act, and specifically considering that Indonesia is part of the Association of Southeast Asian Nations, which is different than the EU as a supranational body. So what do you think Indonesia could take from the DMA, and how maybe different the situation there is in Indonesia to have a similar framework as we now have in the EU?
Mm-hmm. Thank you so much, Inge, and thank you, Ibu Soraya Sakina, for the question. It's a very important but not easy to answer question. But I would start from since you mentioned ASEAN, I will start with ASEAN. So from ASEAN, then we go to Indonesia. So in terms of ASEAN, correct that we don't have that thing that the European Union has. So we do not have what we call a supranational body. In ASEAN, we have this principle, we call it the ASEAN ways, meaning that you can check my garden, don't touch it, don't comment, just see, and you admire my garden is fine. So so what ASEAN relies on really is commitment, but this commitment is not something that you can force. So the ASEAN member states should they want to keep their sovereignty, their freedom to decide whether they want to take a certain step or not. So far we have guidelines. We have regional guidelines on competition law, but this is something that this is something that's not binding in nature. And in terms of from there, if we want to have something like the MA, what I can say is that we could have that concept, but we could not. I think we could not let's say not in the 6, maybe 10 years. Maybe after 10 years we can, but until then, I think it would be different from how it is implemented in Europe, because it is not binding. So we can have the principles, we can have the concept, but it would remain in what we call soft law guidelines, for example. And then from there, we in ASEAN we use this method, what I would say nudging. Like when you have these guidelines, you send the message all over ASEAN member states that this is something good, you can try, but don't feel obliged. Okay, but you have this nudging. So with this, you can say, oh, you try. If it works, then you can do it. So this is something that maybe once we have guidelines in that direction, then the ASEAN member states could get the principle, but it takes time. It cannot be as fast as in the European Union. That is first. The second part is Indonesia. How about Indonesia? Whether well, okay, as Inge explained, the DMA applies in European Union level, right? That will not be the case in ASEAN because of the thing that I explained before. Yeah, but after 10 years, maybe different. Now with Indonesia, what can we do? Should we adopt something like DMA, but for national level? Well, this is something that we need to consider, but I would say first two things. One, we need to update our competition law, not directly going to the direction of DMA, but we need slowly to update it. For instance, we still don't have what we call leniency program in our competition law, which is very important if we want to tackle cartel cases. We still can, but it is hard. Okay, and we need to improve also the power of the competition authority. That is very limited at the moment with the current law. That is first. And I think I agree with Inge that the DMA goes hand in hand with the exposed regulation of competition law. I think this is not something that we have either this or that. So for Indonesia, then with that update, and then we can take certain parts that could be important for us, but I cannot say that we can now let's adopt the DMA. This is something that I would not say right now, like right away. I mean, because there is a reason why the DMA applies in the European Union level and not in a national level. There is a reason for that, and but if you ask about what can we learn, something that we can learn, as Inge also mentioned, with the DMA, there is also, Alicia has mentioned, there is a nice thing there. I like it a lot. This is when you can deal with the problems with the definition of relevant market, which is very, very difficult in the digital market. And with the DMA, you can tackle that problem. And so maybe that.
Yeah.
I think
No,
I will
thanks
stop
a
there.
lot. That's interesting reflections indeed. How it's more difficult to transpose such an EU framework in the Indonesian context. So there is still one other question in the comments, but I will keep that for later because we still have one round to go and we haven't heard Tivana yet. So I'm eager to hear your insights, Tivana, on the ongoing development in competition enforcement in Indonesia, and happy to hear your reflections as well.
Thank you, Inge, for giving me this opportunity. So I will not share my presentation then. Okay, thank you. So I just continue what Yuli has explained before, um, and then maybe some items that Yuli already explained that maybe I will not repeat it again, but maybe we can see other aspects of my presentation. So I would like to discuss about the enforcement and the case related to digital market in Indonesia, and I will also give the examples of the cases of digital market in Indonesia. Next, please. Okay, so first of all, I would like to start with the finding out what are the challenges in digital market in Indonesia. So there are 4 challenges that I found somehow. And the first thing is the legal framework. And of course, we know the actual task of the IC's Indonesian Competition Commission is to monitor competition activities to ensure that they comply with all the existing regulations and rules. However, it's not as straightforward as it implementations. And one of the challenges faced by the ICC in supervising companies, especially in e-commerce, is the open market nature that allows unlimited participants to enter the digital market. And also, of course, this market characteristic makes it difficult for the ICC to identify competition violations within the e-commerce companies. And the lack of regulations governing the digital market is seen by the ICC as an urgent matters for the government to address, as the market structures really differs significantly in various aspects compared to the conventional markets. And since the existing regulations are limited, the ICC needs to establish some commissions regulations and also some guidelines regarding the digital market that I will later on discuss it on my next slides. Also, we already discussed about some characteristic of the relevant market, and Yuli also mentioned it in her presentations. Well, for the market structures, of course, the competitions in digital market mainly based on the innovations that for sure to attract consumers for their products. Yeah, and as a result, somehow the digital market is dominated by smaller numbers of the companies that maintain a strong market positions through ongoing innovations. And at the same time, relevant market also needs to be updated to follow the digital market competitions while responding to the diversity of competitors and also the consumers' preferences. And for the use and control of data, I think Yuli already mentioned it about our Indonesian data protection law. And well, by combining user data of platforms, several platforms, companies can really optimize their markets somehow, and then therefore personal data holds strategic value for the digital platforms, and it helps to maintain the market positions by analyzing large volumes or data, or by creating a competitive over their competitors. And the control about potential abuse and discriminatory practices coming to the digital market development in Indonesia. One of the examples of the violations of the competition is predatory pricing. It's tends because Indonesian consumer tends to support predatory pricing, practices, as they are mostly increasingly consumer oriented and tend to rely on one single sources to purchase products. And predatory pricing is commonly found on e-commerce platform in Indonesia. And although the e-commerce sells goods at a loss, it experiences temporary losses by and eventually the company can gain significant profits through the steady customer base. And one of the other competition violations in online businesses is the abuse of the dominant position, where it's online in line in Article 25 of the Law Number 5 of 1999, and that states that business actors either directly or indirectly are prohibited for preventing consumers from obtaining goods or services that can disrupt the competition. I think some abuses of dominant positions on digital platforms include the refuse to deal, exclusive dealing, some loyalty discount, tying and bundling on different products in single package. That's the most common thing that happens in Indonesia. And also the last one will be the control of merger, even though we already have the ICC regulation number 3 of 2023 that introduced an electronic delivery system, also established provisions for the valuations of assets and sales of assets. It somehow still be the mandatory post of the notifications, and ICC needs to accommodate electronic notification service in order to to be more effective and efficient in regulate the assets value. Okay, please next on my slide. Thank you. And here are only a few guidelines. Only a few guidelines because the ICC has made a series of guidelines to improve the competition enforcement, especially related to digital market, even though not directly relevant. Not all are directly related. But these three new guidelines play a significant role in handling competition cases, including digital market cases, and had been using data-driven and economic quantitative based approach. And as you may see that they all have their objectives. As the first one is to update the rules for defining a relevant market, and the second one, the second ICC chairman regulations is focusing on the providing the criteria, indicator tasks, and steps that can be applied to measure and determine the negative impacts. And then the third one is more focused on the bid rigging, and the last updates to use the more indirect evidence and also put some other category in the collusive tendering and the bid rigging, such as that they may not just the business, not just the vertical or the horizontal bid rigging, but there are also some extra specific features of the tender, such as the objectives and proposes, applicable regulations, coverage area, and also some timings that they offer. Okay, thank you. Next.
Just to let you know that you have about 3 minutes left, because I know
Okay.
that you still have various slides, but you may want to
Yes.
pick and choose or speed up a bit.
Yes, I think
Thank
I
you.
will not. I think I will not explain about this because I think I talk about it, and I think I will go straight to the cases. Is it okay?
Yeah, sure. So then we
Okay.
move to the next slide, I think.
Okay. Thank you, Inga. Now, okay, this is one of the Shopee case. Is actually we can see it. Maybe it's too small for you guys to see it. And it goes to, there are some findings in this allegation. I try to make it very short. And it shows that the ICC assessed that Shopee actually held the dominant positions in the marketplace, and it's evidenced by the consumer surveys showing that most of the nearly 1,000 respondents identified Shopee as their top of mind choice for marketplace. But what is interesting in this case is because the the ICC the Shopee, sorry, the violation have caused direct harm to consumers and also exclusionary practices by prioritizing Shopee Express, yeah, the affiliated company. And to be exact, and then the Shopee cases, I think it's not it's not going on because they already reviewed some behavioral change, and they have the commitment to change the behavior towards the uh, allegation from the ICC. And then the next case. And this is an ongoing case that happens in Indonesia, and this case is still ongoing exactly now, and you can find in the websites of the ICC. The stage of ICC investigator witness examination now is stopped there right now because the accusation is also quite similar with Shopee, but in this it has more violation, which is the Article 17 that focus on the monopoly in article in the law number 5 of 1999. And it shows that I took these cases because it shows the difference that actually ICC can offer some behavioral change and the pact of the commitment, including the self-compliance from the business actors, actually. Okay, could we go to the next one? All right, so the needs of the regulations in digital market, even though we already have some mostly from the ICC chairman regulations and also the ICC regulations, there is needs that some platform rules needs to be revised, especially regarding the platform integrations, and of course the implementations of the current regulations, and also the need for a more specific digital market regulations. And we need more than just the regulate the relevant market definitions, and of course some lesson learned from other countries regulations, as Yuli has described and then already stated that it is very interesting to see what happens in the European Union with their DMA, but maybe it's not really practical to be applied in Indonesia for now. And while what can we get? What can we find that some progresses that we need to admit in Indonesia as well, such as, for example, the ICC regulations number 1 of 2022 concerning the competitions compliance program consists. It is provided for the business actors who are willing to make the commitment with the ICC, and the program itself consists of 3 parts, like conduct of ethics, the competitions and sanctioned antitrust handbook, for example, and also some specific either general or even specific topics of the training. And what can the business actors do with by agreeing on this program? They need to register, and also can also give some proposals that needs to be reviewed by the ICC. And the program itself is for sure voluntary, it's not an obligations, and it can be valid for 5 years and can be extended if both parties are agreed. To get to do this, of course, business actors has to get some benefits as well, and the benefits is the uh, possibility of reduced fines that will be determined by the ICC panel of commissioners as case by case basis. So we don't, I mean, there's no clear regulations or statement in the guide in the regulations number 1 of 2022, but well, there's no exact discounts or anything, but it will be decided later on from the perspective of the ICC. I think that's all that I'm going to say. Thank you.
Okay, thank you very much for that presentation. Especially the cases you explained were very, very interesting. So I am going to conclude with a final presentation on some developments that we now have actually in Dutch competition law. And if we move to the next slide already. So we have explained already that the DMA is now something that is being developed and enforced in the EU, but at the same time, competition authorities still feel that they do not have the right tools to remedy increasing market concentration across the economy. And to address this, some countries are considering to introduce a market investigation tool that is modeled after the UK example. I will get to it in a couple of slides. But part of the result of this being discussed now also in the Netherlands is a study that we did with TILEC, the Tilburg Law and Economics Center for the Dutch Economics Ministry, on whether the Dutch abuse of dominance provision could still be enforced effectively. And here you see both our report on the left, which is quite lengthy if you want to have a shorter summary, and a follow-up paper that discusses the market investigation tool more specifically. You can go to the article on the right, which is a publication in the Journal of European Competition Law and Practice. So the question that we were asked to address was indeed, can abuse of dominance still be effectively enforced in the Netherlands? And in the report, we tended to answer that question with a no, because of several reasons. First of all, that there is lack of clarity about the legal norm in abuse of dominance cases. Extensive economic analysis is required, but it's often complex and also often not conclusive. There's a high standard of proof, and there is also market problems that do not constitute an abuse. So based on that, in the report, we also came up with several recommendations. And one of the recommendations was to investigate whether there's a need for additional tools in the competition toolbox. And one of them could be a market investigation tool. So if we go to the next slide. So one of the reasons that abuse of dominance enforcement is quite complex in the Netherlands is that, we have unclear standards of abuse, and also parties challenge everything and also have the incentives to do that. Like a competition authority has to defend its decision on the basis of the facts and information that was available at that time. But when parties appeal, they can also include other pieces of evidence that the courts then have to consider. Beyond that, there is also a very high standard of proof, and this is partly because competition violations have a semi-criminal character. Which also means that in the European setting, the European Convention on Human Rights applies, which means that companies are protected by fair trial and by the presumption of innocence. And we can also see that the EU courts take that very seriously. And here on the slide, you see a quote from the General Court in Luxembourg in the Google Android judgment, which said that any doubt in the mind of the court must operate to the advantage of the dominant firm. So taking that presumption of innocence very seriously. You can imagine that this sometimes also creates problems on understanding what exactly is then enough to prove a violation of abuse of dominance. And in the study, we also saw that the standard of proof applied by the Dutch courts is quite high. It's the standard of beyond reasonable doubt. And one example of a case where this led to problems was a case against the Nederlandse Spoorwegen, which is the Dutch railway company, which is a bit of a complicated and odd case in terms of like the practice that was at stake. It was about public procurement procedure, but actually the case in appeal was annulled because the courts were not convinced that the Dutch railway company had a dominant position beyond a reasonable doubt, even though the company has like 90% market share. And despite that, the courts were not convinced beyond reasonable doubt that the Dutch railway company could act independently from businesses, from consumers, and especially from the Dutch government. So just to show you an example of how high the standard of proof as applied by the courts sometimes is. So then if we move to the next slide, so in the study, we also looked at some of the data that the Dutch Competition Authority, the ACM, shared with us on the amount of signals and requests to enforce they get. And here you see those signals and requests in 2020 to 2021, where you see that they receive a lot of signals, 2,627, of which in the end only 39 are subject to initial investigation, which means that they also take a lot of time to filter through signals that in the end may not be so indicative of an abuse of dominance, meaning that they spend a lot of resources in having to respond and investigate signals that actually are not abuse of dominance. Beyond this, they also deal with requests to enforce, where they have a legal duty under Dutch administrative law to respond to such a request to enforce, where in the end only 3 were made it to an actual investigation. So there you see that the Dutch Competition Authority also devotes a lot of resources to actually investigating before a case actually makes it to the investigation stage, and where there is really like a reasonable doubt that there is, or the reasonable suspicion that there is an abuse of dominance. When we move to the next slide, so this is one of the reasons also why this market investigation tool is now being discussed in the Dutch setting, because these problems in the Dutch abuse of dominance enforcement seem systemic. Like it's difficult to point what exactly the cause is. Maybe the competition authority should be more effective in how it handles signals and in requests to enforce. Maybe the courts have a too high standard of proof, so that is not what we can point at in the study. But one way to address this might be to think about having additional instruments for the competition authority. And the market investigation tool, as you see in the press release on the left, is something that the chairman of the Dutch Competition Authority, Martijn Snoep, has already asked for. And market investigation tool means that a competition authority can intervene to address structural market problems without having to establish that there has been a violation of the competition rules. The UK already has a lot of experience with this tool, and they use this also to intervene when there is a combination of factors that leads to market problems. So problems at the demand and also at the supply side. And important to note is also that this market investigation tool can not only be applied in abuse of dominance settings, but also, for instance, in settings where you deal with oligopolies. Like, for instance, on the right, you see here a press release from earlier this year where the Dutch Competition Authority, the ACM, did an investigation into savings rates, where they saw that the 3 biggest Dutch banks lagged behind in terms of their savings rates because there is just too little competition and consumers do not switch. So in that case, there was no violation of the competition rules, but still you could argue that the state of competition and the state of the market was not desirable. So in such a situation, the competition authority cannot intervene because there is no violation, and it's basically up to the legislator to then, for instance, impose additional legislation in such cases. Then if we move to the next slide, so keeping this in mind, you could see a market investigation tool as a form of more proactive monitoring, where the relationship between the regulator and market players is not so much adversarial anymore, but it's more cooperative, where they look for whether the most effective remedies, for instance, to solve a particular market problem, not making anyone responsible for the problem or not establishing who is guilty of the problem. So that also means that there is no fines in this system and that the punitive nature of intervention disappears, which might also then mean that the standard of proof in such cases is more reasonable. And because it's not so much anymore about proving a violation, the time and effort will shift to having effective remedies instead. Nevertheless, we also know from the UK experience that it can still sometimes be tricky to design effective remedies in market investigation, in market investigations. So the biggest question that we are now handling in the Netherlands is, if we want such a tool, how should it then be designed? And it is a tool that would give a lot of discretion to the competition authority, where also the issue of democratic legitimacy comes in. Because if the competition authority would, for instance, be able to impose remedies on the whole market, also targeting unknown future market players, isn't then that the responsibility of the legislator to act? So what then is a division of powers between the competition authority that can address market problems and between the legislator that has a democratic legitimacy to legislate also for the future? So this is a question that is now being discussed within the Dutch competition setting to see whether and how such a market investigation tool could be introduced. So with that, I am going to stop my presentation and leave the floor for some final questions, because I saw in the chat or in the comments that we still have a few. So the question that I would like to ask first is a question about the DMA and its link with Indonesian consumer law. So if you, Yuli or Tivana, would like to respond to that, I would be interested in hearing your views, especially I think from myself as seeing the DMA from an EU perspective. It indeed also has some provisions that protect consumers. So it has a bit of a hybrid nature, where it's not only just competition and ex-ante economic regulation, but also has some aspects that could also help the consumer protection. So how do you see that? I think we have the wrong question on the screen, but I think you know which question I'm targeting.
Right. Thank you so much, Inge. If I may respond to the question. Yeah, indeed, I agree with you. I mean, you're of course you're absolutely right. There is this aspect of consumer protection in the DMA, and I think that's where this question comes from. However, I would say in terms of Indonesian consumer protection law and how it interacts with Indonesian competition law, I would first say that in Indonesia, we do not have a competition law with dual mandate, meaning that competition law at the same time also consumer protection law. So we keep those two regimes separated. And in this sense, it means that consumer protection law remains dealing cases where consumers or customers, individual consumers maybe, or a group of consumers, they deal with a certain company. For instance, if you order a certain product and you receive different product than promised, something like that. That's an example. In terms of DMA, as Inge said, it has an aspect of protecting consumers, indeed, but with Indonesian consumer protection, I think we cannot say that the DMA is the consumer protection law is equal to the protection under the DMA. For instance, under the DMA, you can tackle issues such as consumers that cannot switch to different platform. This is something that we cannot deal with the consumer protection. Or if you have, for instance, self-preferencing. The cases of self-preferencing, it's not a case that you are dealing with under consumer protection law, at least in Indonesia. So there are differences, but there is an aspect indeed. I agree that the DMA touches upon certain points of how to protect consumers. I think I hope that helps or answers the question. Back to you, Inge.
Yeah, I think that's a good answer to the question, indeed. Tivana, would you like to add something, or do you agree with Julie?
Yeah, that's why I keep on nodding my head, because
Okay.
we have
Then
separate,
there was
businesses,
also a question for you. Maybe let's end with that question, because we are aware that we are running a bit over time. There was a question for you, Tivana, on cross-border mergers with foreign countries. Could you comment on that question? So is it possible in the Indonesian setting?
Well, okay, it is possible to. I mean, Yuli, of course, you can correct me if I'm wrong. But yeah, I think given the Indonesia follows mergers from the newest regulations in mergers, that we don't really have that specific regulations towards the cross-border merger with the foreign country. I mean, not in a spatial issues that we're put it in our merger regulations. And I think, like what I said before, that the regulations in merger in Indonesia is still the post notifications. So there goes some problems and some issues that at the end it can be separated, the mergers, the mergers, or the consolidations or the acquisitions. So that's a bit hard also for the cross-border mergers, I think. So Yuli, maybe you want to add some informations regarding to that issues.
Thank you. Maybe just one point. Actually, okay. The question was about the requirement of 51% state-owned ownership. Well, we don't have a specific regulation saying that it must be that proportion. It really depends. So you go to we need to go to sectoral regulation, and so it depends on the industry. In certain industry, even you have to have the 100% ownership of local companies. So it really depends on which industry you are in. But I would say that the cross-border merger with a foreign company is completely possible. You can do it, but you need to look into the sectoral regulation, whether it is allowed or not for certain industry that you are talking about. I think that. Thank you. Back to you, Inge.
Yeah, thank you very much. This was a very interesting discussion. I enjoyed it a lot. So we have run out of time. So also thank you to the audience for staying with us for so long. And thank you to the organizers as well, and to the technical support for making this panel possible. So thanks for joining us. Enjoy the rest of the winter week and have a great rest of the day.
Thank you, Inge.
Thank you so much, Inge, for
Thank
being
you,
such a
everybody.
lovely
Bye-bye.
moderator. Thank you for the committee.
Bye-bye.
Thank you.
Bye.